Today, the Senate will vote on the nomination of Notre Dame law professor Amy Barrett to serve on the Seventh Circuit Court of Appeals. She's an eminently qualified and exceptional bright nominee who has received praise and support across the legal profession. She clerked for Judge Silberman on the D.C. Circuit Court of Appeals and for Judge Scalia on the Supreme Court. She has experience in private practice and many years as a law professor teaching constitutional law, federal courts, and statutory interpretation, among others. And she was appointed by Chief Justice John Roberts to sit on the Advisory Committee on Federal Rules of Appellate Procedure, where she served for 6 years. Her nomination has also received wide support. For example, in a letter to the Judiciary Committee, a bipartisan group of law professors encouraged the committee to confirm her nomination, saying that Professor Barrett, quote, enjoys wide respect for her careful work, fair-minded disposition, and personal integrity, end of quote. And her colleagues at Notre Dame described her with this quote as a model of the fair, impartial, and sympathetic judge. Despite this, all the Democratic members of the Judiciary Committee voted against her nomination in committee, and I suspect most in the minority will vote against her confirmation later today. This, of course, is a shame, and it does not speak well of our institution, the United States Senate, and I would like to explain why. When the Judiciary Committee voted on Professor Barrett's nomination, I listened to the reasons my colleagues gave for voting against her. Some said that she didn't have enough experience to be a circuit court judge. Well, the American Bar Association rated Professor Barrett as well qualified. The Democrats have said that the ABA's ratings are very important to them when considering a nominee, once even calling it the gold standard. Their votes certainly don't reflect that. I suspect the ratings don't actually matter to them since they voted against most of the well-qualified nominees this Congress. The minority has even requested that I not hold hearings on nominees when the committee hasn't received the ABA ratings for that nominee, as if the ABA, an outside group, can and should debate the committee's schedule. But even when we have well-qualified or qualified ratings from the ABA, the minority still votes against these nominees, so the actual significance of the rating to the minorities doesn't make a lot of sense. Furthermore, lack of appellate experience hasn't mattered before. When President Clinton nominated Justice Kagan to the D.C. Circuit Court of Appeals, she had no appellate experience. But I remember my friend from Vermont saying that the Senate should vote on her nomination because she was, quote, an outstanding woman. Her lack of appellate experience didn't appear to be of concern to my friends in the minority at the time of Kagan's nomination coming before our committee, so I don't understand why the standard is different now. Another reason some of my colleagues gave when voting against her is that they say she'll disregard judicial precedent. Of course, if that's true, that would be a very serious consideration. But looking at all of Professor Barrett's writings and listening to the testimony she gave, not once did she say that circuit or district court judges could disregard precedent. In fact, during her hearing, she told the committee that she understood, quote, circuit judges to be absolutely bound by the precedent of the Supreme Court, and then further quoted, circuit courts are bound to follow the precedent of their own circuit, end of quote. That doesn't sound like a nominee who won't respect precedent. In fact, she understands exactly the role of precedent and the limitations and restrictions placed on lower court judges. Another senator argued that she has written provocative things like, quote, "A judge will often entertain an ideological bias that makes him lean one way or the other. In fact, we might safely say that every judge has such an inclination," end quote. I'm not sure why this statement is provocative. I think that everyone here knows that every person has their own biases and policy preferences, whether they're a judge or not a judge. In writing this, Professor Barrett shows the awareness to recognize that every person comes to their job with personal biases and views, and this is especially important for a judge to recognize about themselves. In fact, she's so self-aware that this is a potential problem for judges that she co-wrote an article arguing if a judge cannot set aside a personal preference in a particular matter before that judge, she shouldn't hear the case in the first place. Now, these comments come from an article about potential issues Catholic judges may face that Professor Barrett wrote in law school. The article was about Catholic judges, but could have been written about the biases of judges of any religion or of no religion at all. My friends in the minority have looked at a few of her comments from this article and seem to have concluded that she'll base her judicial decisions off of what her religion teaches. During her hearing, one senator even implied that Professor Barrett can't separate her religion from her judicial decision-making. But Professor Barrett has said and argued quite the opposite, and doing it several times. She believes it's highly inappropriate for a judge to use their own religious beliefs in legal reasoning. In fact, she concludes the very article the Democrats are concerned with this way, and I quote, "Judges cannot and should not try to align our legal system with the church's moral teachings wherever the two diverge," end quote. I think opposition to her nomination ultimately comes down to the fact that her personal views about abortion don't line up with the minority views about abortion. I knew the minority would ask her about her views on abortion, so during her nomination hearings, I took the advantage of being first to ask her if she'll allow her religious views to dictate her legal decisions. She said that she would not. I also asked her if she'll follow Supreme Court precedent involving abortion, and she simply and succinctly answered, "Absolutely, I would." At her hearings, the statement was made, now can you believe this? You're controversial because many of us that have lived our lives as a woman really recognize that the value of finally being able to control our reproductive systems. That sentence is a direct quote. This statement alone is stunning to me for two reasons. First, that a nominee is controversial because she might share the views of over half of the country does, that abortion's wrong, and second, because this statement amounts to a religious test. In response, Professor Barrett said over and over that she has no power to overrule Roe or any other abortion-related Supreme Court case, nor does she have interest in challenging that specific precedent. A further statement was made that, quote, religion has its own dogma. The law is totally different. And I think in your case, Professor, when you read your speeches, the conclusion one draws is that the dogma lives loudly within you, and that is, of course, when you come to big issues that large numbers of people have fought for years in this country. End of a direct quote. So, the Democrats are saying women who have personal beliefs consistent with their religion aren't eligible to be federal judges, even when they assure the committee, as she has over and over again, that they strongly believe in following binding Supreme Court precedent. If that's the case, if the minority is enforcing a religious litmus test on our nominees, this is an unfortunate day for the Senate and for the country. Others have spoken on the issue of a religious test, but I'll remind my colleagues the Constitution specifically provides that, quote, no religious test shall ever be required as a qualification to an office under the United States, end of quote. It's one of the most important founding principles. I don't think an evaluation of how religious a person is or how religious they might not be should ever be a part of that evaluation. We received many letters on this topic, including one from Princeton University president, who's a former law clerk to Justice Stevens and happens to be a constitutional scholar. He writes that the questions Democrats posed to Professor Barrett about her faith were, quote, not consistent with the principles set forth in the Constitution's no religious test clause, end of quote, and that the views expressed in her law review article on Catholic judges are, quote, fully consistent with the judge's obligation to uphold the law and the Constitution. Finally, this morning, my friend from Illinois justified the Democrats' questions in committee to Professor Barrett by noting that I also asked questions about her article in the committee, but there is a difference in simply asking a nominee if her religious views will influence her judicial decision-making and trying to ascertain just how religious a nominee is by asking this question: do you consider yourself an Orthodox Catholic? End of quote. And saying an additional quote, the dogma lives within you. My questions gave Professor Barrett a chance to explain her law review article, an article I knew Democrats would question her over. The other side's questions and comments went to figure out just how strongly she holds her faith, which was the inappropriate line of questioning. I'll make one more related comment. I mentioned this in the Judiciary Committee, but I think it bears repeating on the floor because the issue will continue to come up. Professor Barrett and a few other nominees have a relationship or ties to the Alliance Defending Freedom. That's a group which, as several senators have recently pointed out, has been labeled a hate group by the Southern Poverty Law Center. Now, when the nominees are asked about this, they have pointed out that the Southern Poverty Law Center's designation is of itself highly controversial. I'd say it's completely unfounded. ADF, the organization Alliance Defending Freedom, is an advocacy organization that litigates religious liberty cases. They've won 6 cases in front of the Supreme Court in the past 6 years, including cases related to free speech and children's playgrounds. They're not outside the mainstream. Any difference in viewpoint folks may have with them boils down to simply policy differences. But dissent and differences of opinion do not equal hate. And it's wrong to compare an organization like ADF to that of the Ku Klux Klan or the Nazi Party, and by extension, imply that the nominees before us sympathize with such actual hate groups. Finally, I'd note that the Southern Poverty Law Center designates the American College of Pediatricians and the Jewish Defense League as hate groups. So some of the Southern Poverty Law Center's designations appear to be discriminatory in and of themselves. Professor Barrett is a very accomplished, impressive nominee, and we know her personal story is compelling. She has seven children, several of whom are adopted from Haiti, and one of whom has special needs. She's an accomplished attorney and well-respected law professor. I'll be strongly supporting her nomination today, and I urge every one of my colleagues to do the same.